the work that we're doing on prisons, both the prison build, but also the massive agenda now to get offenders off drugs through abstinence-based rehabilitation. I think that's one of the things that has really shifted since we last spoke. Also getting offenders into work, both a big step change in the approach of prisons, and I can talk a bit about that. Yep. That's showing up in the data for offenders getting into work. But also a lot more to do. And I would also add to the very top priorities, violence against women and the RASO agenda. Again, we've seen an increase by about 2/3 of convictions over the last year, but a lot more for us to do. Those I would say illustrative example of the very top priorities.
Okay. Well, that's very helpful too. And let's touch upon the financial situation briefly, if we might. I mean, the autumn statement doesn't change the department's budget, but it does mean that you're going to have to absorb the inflation costs within the existing sum. What do you think is the impact is going to be of that on services?
So I haven't done the specific allocations, but I think it was timely and useful to start with the priorities, because that tells you the areas that I'll want to protect and safeguard as a priority. The overall departmental spending bearing in mind we're an unprotected department, the overall departmental spending will grow at an average of 3.7% per year over the SR period. We'll have to find the efficiency savings to manage the inflationary pressures, and of course that is not known precisely at the moment either. After the SR period, the day-to-day spending will continue to grow in real terms, but more slowly than previously planned, at 1% a year in real terms until 2027, 2028. The capital spend will increase as planned for the next 2 years, and then maintained in cash terms for the following 3 years. And I'll need to do the allocations. Look, we're going to have to find some savings to absorb the inflationary pressures, but I'm confident that we can do it in a way that protects our core priorities.
Okay. Do you have a sense yet as to where those savings might be, or is it too early to say?
Well, I can't give you... what I tend to do is, rather than say, some people do a sort of percentage slice across the board, I'm not going to do that. I didn't do it when I was Foreign Secretary with the ODA budget. What I would much rather do is set out the core priorities that I want to minimise the impact and safeguard and prioritise, and then see what the choices are. So the allocations process is very important for us, but I'm confident that we've got enough flexibility in the overall budget to keep driving forward what is an ambitious reform agenda.
Do you think the capital programme will be adequate to deal with, for example, pressures on the condition of the courts and the prisons and so on?
Well, I always make the argument that if you don't make sure that you've got the provision in place for that, it's a false economy anyway, because you lose sitting days in prison, you lose prison places. I mean, that's ultimately what happens, they fall out. So, look, it's going to be a challenge overall, but I'm confident we'll do that. And of course, we have a substantial prison build agenda going forward. That's obviously been unsettled by the inflationary impacts, not just on our spend, but on contractors and things like that. But I'm still confident if you look at, if you look at the progress we've already made, Five Wells, Foss Way, H&P Full Sutton, major refurbishments at H&P Birmingham, H&P Liverpool, a house block at H&P Stockton. So over 3,000, I think it's 3,100 places have already been delivered. We'll keep driving that forward.
Turning to the position of courts, for example, I notice quite frequently we're now getting statistics that show something like 50 or so courtrooms regularly out of use, something about 14% of the Crown Court space in particular not being available to use on a daily basis. Largely because of poor maintenance, and that was raised to us as well by the Lord Chief Justice when he gave evidence to us. How much is that going to be a priority?
Yeah, I think that is a priority. I mean, first of all, we've got the backlog, the Crown Court backlog. It was down a downward trajectory, and I'm disappointed. Obviously, we know that the industrial action set us back. But as we redouble our efforts to get it down, obviously it's going to be a priority to make sure that where we've got courtrooms that can and should be used, that we've got the maintenance in place to do that. And obviously, because of the Concordat, that's something where, and through HMCTS, I have a very constructive working relationship with the Lord Chief Justice.
There is a shortfall in the round of appointments to the Crown Court. For example, it was about 16 short last time, and we're about to have a new chair of the Judicial Appointments Commission take post. What discussions are you having with the Judicial Appointments Commission and the Judiciary to try and make up that shortfall in recruitment to the Judiciary?
There's a whole range of things that we're doing on the courts recruitment, the judicial recruitment, obviously the increase in the retirement age. We've got a recruitment campaign at various different levels underway. That's just something that we are in constant conversation with HMCTS about. I think there's also a question around diversity in perhaps a slightly broader way. There's obviously the obvious diversity challenge in the senior judiciary, but more generally encouraging more people into the profession. And we've taken some steps recently to increase solicitor audience rights. We've also taken steps to increase what SILEX qualified solicitors can do as well, including things like audience rights. And I think overall, when you look at the marketplace for legal practitioners, there are going to be broader routes in, and over time, that should filter through into the judiciary. I mean, obviously, there's limits to the audience rights for the and the positions that SILEX qualified lawyers can go for, but let's see how we go. But what I do think is by increasing the base supply into the profession, we'll be in a stronger, more resilient position over the longer term.
Okay. To what extent do you think the working conditions for the judiciary are an impediment to recruitment?
I think that's something that in the context of maintenance you do hear mentioned.
Yeah.
So that's why those issues, I mean, perhaps as much as the purely pay and rations, if you like, I think that does make a difference. Yeah. So that's something we will look at very carefully in the same way.
Feeds back into capital programme and maintenance programmes, doesn't it?
Yeah, I mean, I've got the figures here. We're recruiting up to 1,000 judges in 2022-23. We've, as you know, removed the limit on sitting days in the Crown Court, but just in terms of recruitment, that's the current year's tally that will be coming in.
Thank you. Mr. Turner.
Thank you very much indeed, Chair. Lord Chancellor, last Tuesday the committee heard evidence, powerful evidence I have to say, from the criminal legal aid solicitors and the Law Society. They spoke, amongst other things, about the pressure on individual solicitors in that practice. Mental health was mentioned as well. And they described to the committee that the profession is on the verge of collapse. So why didn't you implement Lord Bellamy's recommendation to increase fees paid to solicitors working in that sector?
So, look, I came up through the solicitor profession myself. I've got great respect, esteem, sympathy for the work they do. I mean, overall, as you know, Carl, we're increasing investment in the criminal legal aid by 135 million, 150 million to uplift most fees by 15%. 20 million is going towards the longer term reforms. There is a full consultation response on the longer term reform, which we will be publishing by the end of this month. So you won't have to wait too long for that. Just on legal aid solicitors in particular, and by the way, I'll be meeting with the President of the Law Society shortly, but we have already, there's some things we've already done, there's some things that are coming down the track. Would it be helpful if I just talk you through them? Or do you?
Perhaps, yes.
So we're uplifting fees for the majority of schemes by 15%. We're providing a 5 million uplift per year for fees in the youth courts from 2024 to 2025. We've also committed to launching an advisory board to provide advice on criminal legal aid schemes. The next step, which I don't want to trail too much of the detail on, but I think I can give you the principles that will be guiding what we set out shortly. It's going to be how the £20 million for the longer term investment will be allocated, and in particular how it will support criminal legal aid solicitors. It will deal with recommendations from the Bellamy Review on reforming fees for police station work, which I think, Carl, is something you've raised with me before. It will deal with Claire's recommendations on the LGFS. I do think it's important to reduce the reliance on pages of prosecution evidence and deal with some of the unintended incentives around that. It will also look at how we can support a viable criminal legal aid market, and then that wider question about diversity in the round. So this is all coming soon. There's some stuff we've done. There's some stuff that's coming.
You accept, though, Lord Chancellor, that the profession really is about to collapse unless you're willing to change your approach and increase the fees under the litigated graduated fee scheme of 15%. Would you accept that it truly is
Look, I
on
think
the brink of collapse?
I'm not sure that's the word I'd use. You won't be surprised to know, but I do think that we've got to address that second phase of longer term reform and try and look at this as a market as a whole and make sure it's vibrant, sustainable, and diverse enough that we can, as I say, deal with the long term. So I accept the case for this second phase of reform, and money is going to be an important part of it.
What's the timeline for implementing the LGFS scheme to 15%? Have you got any sort of an idea?
As I said, we're going to be publishing this very soon. I don't want to trail bits of it, but I will be publishing it, I can tell you, by the end of November.
How many criminal legal aid firms do you think will be operating by the time you, if I can put it like this, get your act together?
Well, look, the fundamental thing we've got to try and do is make sure we service the need. And there's a whole range of ways of doing that, but I'm confident that we have the means, but also the structural reform to make sure that there is a viable sector, because the sector is important, because we respect the work that the lawyers do, but also because of the need that's out there. I mean, fundamentally, as much as I love the profession from which I came, my job is to try and make sure that for those vulnerable people that need that advice, they get it. So we're focused on that, but I think that does mean, inevitably, that we need a viable sector, and I think our reforms will deliver that.
In 2010, Lord Chancellor, there was 1,861 criminal firms of solicitors with duty contracts. We were told in the evidence session last Tuesday that that's down to 964. What's your contingency plan if this entire thing collapses? Do you have one?
Well, I think we've got enough flexibility in the system, enough investment going in, enough practitioners being willing to do the work, and look, the money is important, and I accept that. We've got to put it structurally on the right footing to be viable, not just for the short term, but the medium and the long term. So I'm confident that we can do that.
So there's enough practitioners willing to do the work. Where are they?
Well, look, they're there.
Where are they, Lord Chancellor?
Well,
we say they're there, but with respect, where are they?
No, I think they are there. There's certainly been a shift from, I think previously there would have been criminal legal aid solicitors and barristers who would have exclusively done that and taken a whole career out of that. There is now more sort of joint working in other areas as well as criminal. But I think once we've got the funding going in, I think we've got the people with the qualifications, the experience to take up that work.
In 2017, Lord Chancellor, there was 5,240 duty solicitors on rotas. The numbers now are 3,825. Does that worry you?
I think what I want to make sure is that those that need that support get it. And there's been this argument about refocusing on, if you like, advice earlier down the track. So what we do on police stations is very important. There are all the other areas of work. So it's not purely a question of the numbers, although I accept the numbers are important. What matters is how the work is done. And I think getting advice in earlier for those who really need it is a big part of that answer.
There are areas of the country, Lord Chancellor, that literally do not have a duty qualified solicitor to attend a police station or a magistrate's court. Now, when alleged defendants are not represented in proceedings, it's not just those defendants that suffer, it's victims of crime, isn't it? Does that not worry you?
The system operates as a system, of course, and changes made in one area ricochet right the way through. But I mean, look, that's why we always have things like supplementary support. I'm not saying it's a substitute for, but it's always there. The civil legal advice telephone service is one example of that. That applies wherever you are in England and Wales. And of course, we keep the provision in terms of, you were talking about scarcity or deserts, as they're sometimes called. That's something that's kept constantly under review by the legal aid agency, and they've got measures and action that they can take whenever there's a particularly acute problem.
You do accept that there's a major issue, don't you, that you need to address?
I don't think the system has been is on a sustainable footing. I think Claire gives us the opportunity to reset that. I think we've shown as we've approached it, we've accepted almost all of the recommendations from the Bellamy review. We've implemented them. We had to take the time we did to consult. That was a statutory requirement. I know there could be some argument about how quickly it came on tap. And then there's the second step, the £20 million, the wider long-term reform. I think we're grappling with all of that. I mean, if I'm, Carl, when I came in little more than a year ago, none of this had been done. We were still waiting for the Bellamy review. It now has been published. I published it before Christmas. That was what the CBA wanted me to do. We've moved as swiftly as we possibly can. So whilst I appreciate some of the critique, the criticisms, and the concerns, actually, if you look what we've done in the course of just a year or so, we've actually moved this forward dramatically in a way that hadn't been happening before. So I understand some of the frustrations there, but we now do have a reform agenda that is motoring forward. The money is coming through, and we've shown we're serious about it.
Well, you've mentioned the sort of timeline from you coming in, but I've got the chronology of that here. You were appointed, I think, in September 2021. On the 14th of March 22, 94% of the criminal bar CBA members voted for industrial action. I think I raised it the very next day in the chamber with you on the 15th of March. I think you accused me of being the shop steward for lawyers, criminal lawyers.
I meant it as a compliment, Carl.
Well, it was taken as a compliment, Lord Chancellor. You're very kind. Between April and June, the CBA undertook a system of no returns, a form of industrial action. June to July, CBA staged partial and escalating walkouts. There was then in August, 80% membership of the CBA voted to escalate the action. I think the strike began on the 5th of September. I think you were sacked on the 6th of September by Prime Minister Truss. And then the new Lord Chancellor, the Right Honourable Member for Great Yarmouth, came in and sorted it all out in a matter of a few weeks. Are you up to it?
So, Carl, first of all, I came in September. By December, we had not just published Claire, but we had also given a direction of travel. So that was a matter of 3 months.
You spent months refusing to meet and speak with them.
No, I met Joe Sidhu before Christmas, and indeed the reason we published it before Christmas was on his advice. But look, I thought that the strike action was entirely, although I'm sympathetic to the pressures on the criminal bar, I didn't think it was warranted. And by the way, the cost of what it took to settle that is over £50 million. So whilst I'm not going to backtrack on a deal that was previously done, the idea that a magic wand could be thrown at this, or it was just a question of a diplomatic fix or niceties, is not the case. And
if you'd not been sacked, Lord Chancellor, they'd still be on strike, wouldn't they?
Well,
victims of crime would still be waiting for trials to be aired, wouldn't they?
First of all, I don't know what they would have ultimately done.
Well, you wouldn't have settled it, Lord Chancellor, would you?
Let me answer your question, Carl.
That's the point, isn't it?
You
wouldn't have settled it, would you?
Are you finished with the question, in which case I'll give you the answer?
Yeah, okay.
Look, I made my position clear. I don't look back on it and think that I was wrong, because I think otherwise you've got to explain where the over £50 million is going to come from. On the other hand, it having been settled, I don't believe in unpicking deals that have been done. I don't think that's quite right as a matter of good faith. So we move forward. But don't pretend for a moment that I certainly don't believe for a moment that that was a warranted strike. I think it did significant damage. I think the CBA didn't behave in a responsible way, and I think that the £50 million pressure that that's put on budgets, given the on top of the autumn statement, is something that I've got to then find. Where would you say that 50 million should come from? Should it come from victim support? Should it come from drug rehabilitation? Should it come for education for prisoners? And those are the real problems in the real world that government ministers have to grapple with. So that money doesn't just come out of thin air. So that was the challenge. But as I said, I want to proceed as a matter of good faith. I don't believe in unpicking deals other people have done. That's not good faith. And so I'll have to absorb that pressure. But don't pretend the money doesn't come from somewhere. It does.
Criminal solicitors at the moment, Lord Chancellor, are seriously considering a form of industrial action. What's your attitude about that?
Look, I think strike action, and this is talked about in various sectors, including the public sector and across the Whitehall. I don't think it's the right thing to do now. I understand the pressure on pay and fees, but of course there's 2 points. There's a systemic point, which is that if we agree to unsustainable, beyond inflation pay increases, that will make inflation last for longer. That will undercut the poorest in whatever the sector is, because inflation will stay higher for longer, plus the impact on interest rates. I also think, in the context of Clare and the way that we accepted the overwhelming majority of recommendations, both for the bar but also now for solicitors, that we are coming up with a fair deal. 15% uplifts in fees, which is the obvious thing that we've done. I mean, that is well beyond the increase that many others in the public sector are getting. So I think it is, I'm sympathetic.
15%?
Well, of course.
They say 9, don't they? Well, and that's from the government's own impact assessment. They say it's 9%.
Who are we talking about?
We're talking the LGF scheme, isn't it?
Yes, okay. On the LGFs.
But look, we accepted the recommendations. I think they were balanced. I don't think the financial situation has got easier since Clare was published. It's got more challenging. But I think we need to do right by the profession for all the reasons, believe it or not, Carl, you and I share. But putting more money into these areas now compared to what's happening elsewhere in the public sector and in the private sector, I'm just not convinced is the right thing to do. So I'll engage. One of the first things I said when I came in, I wanted to meet with the heads of the professions.
It's refreshing.
No,
I had that attitude previously.
I did. I met with Stephanie Boyce. I met with the head of the Bar Council. I met with Joe Sidhu. I've always been willing to do that. What I can't do is pretend that there isn't a very real-world choice that we face as a government in terms of the public finances and the envelope that I've got and where that money should go. And I think if you want to make the case for more money than we're committed to, tell me where it comes from. Does it come from the support that we're providing for the victims of violent crime or indeed the victims of rape? Does it come from the drug rehabilitation money that we're putting in and I'm trying to protect? Does it come from the money that I'm putting into ending or reducing reoffending by dealing with homelessness for prisoners? There's got to come from somewhere, Carl.
The problem you have, Lord Chancellor, is that the Law Society and indeed the CLSA have concluded, I think, that the only way to get you to act, or indeed the government to act, is to take strike action. And that's terribly troubling, isn't it?
Well, look, I'm not sure you could throw that in my direction, but in any event, look, the problem that, with respect, you've got is that a critique without a credible alternative and being able to answer the consequential questions of where the money comes from is not a plan. And I'm in the business of putting forward a sustainable plan. So respectfully, I've got to deal with the financial envelope I've got, the choices that in the real world I have to make, and the fact that we have followed, by and large, the lion's share of the Bellamy recommendations. I think that was the right thing to do. We'll continue with that agenda.
You saw the Chancellor of the Exchequer, what a terrible state the profession is in, and the fact that it's suffered immensely in the last 12 years of a Tory government. You mentioned to the Chancellor of the Exchequer that you might need a few extra quid.
So, look, I was I think one of the last departments to settle when we had the spending review. I argue the case very powerfully. The problem you've got, Carl, is that it's all very well for
it's
the...
It's not my problem, with respect, Lord Chancellor,
well,
it's yours.
Well, no, but actually...
It's a collective problem, though, isn't it?
Yes, it is a collective problem. And critique without a credible alternative of your own, I'm afraid, is not particularly credible. So, look, I'm Happy to answer all your questions, but you've always got to ask, where does that money come from? And at a time of precious resource, I've got to weigh in the balance all of those things.
Thank you.
I think we ventilated the points as to where, but can I just press a little bit, Lord Charles, in this respect? You said that you will be meeting the Law Society.
Yep.
Will that be including discussing the issue around the outstanding issues with criminal solicitors' fees?
Look, I would never preclude our friends in the professions from raising anything they want to with me. So,
when you plan to meet the President of the Law Society?
I can't give you a precise time, but I know that we're in contact with them. And the Bar Council. And
So given there's that outstanding issue, sooner rather than later, I imagine?
Yeah.
Okay. And the other point that Bellamy was...
I hope that when we publish, which is coming soon by the end of the month, actually, I think what people want to see is action, not just warm words. And so my overwhelming effort has been on driving that forward.
Okay. And when you publish that at the end of this month, hopefully, will that also include some reference to the second stage of Bellamy? Remember, it was intended there should be a system to deal with that. Okay. Thank you. The other point I just wanted to it's probably convenient to deal with it now, is got the position with availability of solicitors, of course, impacts the future availability of the judiciary, doesn't it?
Yes.
And that then leads us to backlogs, because the backlog continues to be substantial, as was ventilated in departmental questions this morning.
Yeah.
Now, you had a target of reducing the backlog in the Crown Court to 53,000 by March 2025. Is that still achievable?
We're going to strive every sinew to hit it, but I can't pretend that the impact of the CBA strike has not affected that. And I think I gave you the figures earlier. We're on a downward trajectory, and it's gone back up. And we're now at the end of September, the figure was 62,500. I monitor it very carefully. So what I'm focused on doing is using all the levers we've got. We've got the extra judges being recruited. We've got the extra money going in. We've had the Nightingale courtrooms. We've increased the sentencing powers. We're doing more remote hearings. We had the super courtrooms as well. So what I'm trying to just do is make sure, as sustainably as possible, we weigh down on it. And of course, in the Crown Court, we're also affected by what all the other agencies, I'm not quite sure it's upstream or downstream, but you know what I mean, the police and CPS
police purposes,
and that puts has a pressure, and of course we want the whole system to be motoring, but it is one system, and the things that happen at police or CPS level have an impact at the court level, and that then has an impact further down the system as well.
I've just noted, actually, I had some up-to-date figures that today 96 out of the 501 Crown Court rooms are not sitting in the UK. Yesterday it was 70, so we're looking at about the 14 to 19% slight fluctuations, and that's not sustainable in the long term, is it?
No, but that tells you the challenge we've got. If the cases aren't ready and I don't have any control over listing, that was an interesting question, the extent to which the Secretary of State can discuss that, but as Lord Chancellor I do have discussions about policy areas, but I can't get involved in individual listing.
Is there a problem, perhaps, for example, with the common platform, again ventilated earlier today, that we're not getting sufficient data to understand what causes part of those delays and the backlog, not being able to record guilty pleas, not being able to record other issues? Does that need to be
We've improved data, and but I think we could always do with more. One of the things I think has been quite helpful is the criminal justice data dashboards, both for crime generically, but also for rape, which is a particular concern. And I would also say that, I understand the criticism of the common platform, but it's live in 173 criminal courts. That's around 76%. We've rolled it out in Wales. I think to the same date, so that's 11th of November, 211,000 cases have been accepted onto the common platform. I think we've had 333,000 hearings managed, and 71,000 hearings have been managed on the Crown, the common platform in the Crown Court. So, there have been teething issues. There are some. There are some technical issues. There's also some cultural change that we're trying to drive forward. But I do think it's important we deliver this and make a success of it.
Yeah. The Lord Chief Justice raised a couple of points with us around the impact that the rollout of Section 28 cross-examinations may have upon listing and the progress of trials. In that it's obviously advantageous to vulnerable witnesses and others complainants to give evidence in that fashion, but that it may actually delay the progress of trials all in all. What's being done to monitor that?
So we ought to, we're raising data on it. Obviously the data takes time to come through and the rollout has been done in phases. I've heard anecdotal evidence of this, but I've heard also anecdotal evidence of the advantages of it, not just for the point of view of the victim who gets the choice. And these may be victims that, if Section 28 is not available, will drop out of the system. So, I mean, it may just be a no regrets decision that there are some victims who will not go forward if they have to give evidence in the open glare of the courtroom. But I do understand that there is a scheduling challenge that it creates, and I've talked to the Chief about it, and I would hope that over time that is something that can be managed sensibly. And we also know that if it can, I wouldn't say there's a universal view, but there's quite a lot of anecdotal support for the measure that I've heard from victims, from practitioners. So I think we need to drive this forward, but I'm mindful of that there's certain things that the prerogatives of the Judiciary. But I think it's been a positive thing overall, but we don't yet have a data to really give you a more granular sense of that.
Is there a thrust to capture that data?
Yes.
Okay, understand. But perhaps we can return to that.
I have to be careful though, because there's some data that the Judiciary is sensitive about us capturing. I'm a data fiend, I want to see more, but I don't want to impinge on things that go to judicial independence. I don't think capturing evidence on this should.
No, I understand that. Thank you for that. At the end of the day, is that target of 53,000 really ambitious enough? Should we actually be seeking to drive that down further?
Yeah, ultimately, the question will be over what time frame, and given that, if you like, the Crown Courts sit, they're obviously from the legal point of view at the end of the process, but in terms of the criminal justice system, in the middle. So I just need to make sure we get that right. But we've got it's a part of the Concord Act that we properly fund the court system. Everyone in government has agreed on that.
Is there a risk, perhaps? The great deal of public attention, understandably, goes to the Crown Court because it's dealing with the more serious criminal cases. Are we at risk of overlooking the situation in the county court and the family court?
I think look, what I'd say is, I'm not. I'm sure public perception is not paying, beyond the practitioners, I'm sure is not necessarily focused on this. I look, on the county courts, we've not yet recovered from the full impacts of the pandemic, but we are investing a lot of time and effort into improving the waiting times in the civil as well as the family courts and tribunals. There's quite a lot of regional variation as well. So there's longer waits in London, the South East. So I need to understand why that's the case. And in terms of family and private family law, I've talked to the President of the Family Division, and we have a very clear now reform agenda. It's starting to operate in the sense of, the way I've said it, I think, before to you, but probably 55% of the cases going to the family courts, private family courts, have some form or other of domestic abuse or safeguarding element to them. But that still leaves 45% where there is a strong case that, other than exceptional circumstances, they shouldn't be going to court. And we need to try and incentivise the ADR. So we've got the mediation scheme up and running. I think the vouchers have been a success, but we need to scale that up. Again, we come back to this issue about precious resources. I want to be investing in things like that. And then I think there is also a very strong case for looking at reform to stop people, if they refuse a reasonable mediated outcome, from then hopping into the court system, just trying their luck, double dipping, if you like. And I would like to look at costs in that context. So I think we've got a very clear plan, and I think very good. I've got to say, I think the Family Division have been brilliant, constructive interlocutors with us on this. But it's up to us now to drive that forward. You'd
accept that there seems to be overwhelming evidence that early involvement of lawyers actually can be the gateway into mediation and can lead to swifter resolution. Is that a point you recognise?
I think it can go two ways. I think but I have heard the argument. I think the thing to do with something systemic like this is get the incentives and the disincentives in the right place. That's the way I'd put it. And I think the not allowing people to mediation is great, but if you just mediate and then think, well, I'll have another crack in the family courts, there's no point. So we need to get that right. But I think when people know that they're not going to get some kind of better financial deal, there's just a huge amount of angst, bitterness that couples, but also children, particularly young children, are spared. And that's what I'm very focused on. And I think there's a real scope to deal with that. And of course, that would help bring the backlog down for those cases, the domestic abuse, the safeguarding cases, that really do need to get to court.
Understood. We've got a target for reducing Crown Court backlogs. The family court backlog is put at 110,000. Is there a target that you're going to be looking at to reduce the family court backlog?
Maybe, but I don't have it on the tip of my fingertips. I'm happy to follow up with you.
Somebody to take away, perhaps?
Yeah, sure.
And then finally, on civil side, the county court is still paper-based. Is there a timeline to digitise the county court? In the same note, we've done that in relation to the High Court.
As you know, the master of the rolls is very keen on driving this forward.
He's going to need the resource. And the
if there's anything, well, there's the resource and there's the will. Of course, not everyone likes the digital process. When we've tried it with divorce or probate, there's been, you never get this entirely 100% support. I think changing to digital involves transition, and some people find that more difficult than others. But I definitely think we should be looking to push forward the digitisation process. I think within a relatively short period of time, practitioners, the Judiciary will get used to it and see the yield and the dividends. I think for the public, there's a massive boon. I mean, I think previously when I come here and I was Courts Minister, driving that forward, I mean, you could see how, first of all, the usage going up, and secondly, the time, for example, in probate and divorce proceedings, how you could increase the speed at which these things get done, which is what most tax-paying members of the public exposed to the civil or the criminal justice system would hope to see.
Are you satisfied with the speed in the probate registry at the current time?
I'm never satisfied. I always restless to go further. But we're driving as fast as we can with resource, and we
recognise there are problems, concerns about delay.
Yeah. I mean, I think there's a great reform agenda there, but I can see the challenges as well.
Okay, thank you very much, Mr. Daly.
Thank you very much, Chair. And I am going to ask you a few questions on IPP, Lord Chancellor. But first of all, I'd just like to take a step back to one of your priorities, and it's something that you've addressed in the Chamber today already, and it's violence against women and girls, and specifically the investigation and prosecution of rape. One of the grave challenges when talking to a government minister, whether it's either yourself or the Home Secretary, is that you have responsibility for separate parts of the process. But I think it's fair for me to put on record here, for the benefit of the committee and people listening to this, the scale of the problem. In the year end March 2022, the police recorded the highest annual number of rape offences to date, 70,333, and charges were brought in just 2,223 cases. Only 1 in 100 rapes recorded by police in 2021 resulted in a charge that same year, let alone conviction. So my question to you, Lord Chancellor, is when we are speaking to you, are we speaking to you purely as somebody who has responsibility for these matters after charge? Because there is clearly a huge problem with the police not referring the vast majority of rape cases to even the CPS for a decision. Do you feel that that stage of this process is something that you should be involved in? If so, do you work with the Home Secretary? What's the cross-departmental working on that area?
So it's a great question, and it is inherently a challenge. Look, every bit of the system understandably claims operational independence. The police claim operational independence, the CPS have independence on charging decisions, and the Judiciary have judicial independence. What we have tended to do is create a safe space where ministers from across the piece, the law officers, the DPP come together, and with the benefit of the data that we now have, particularly on rape, where we can see geographically and step by step through those phases of the process, to create a safe space where we can ask questions, because we all want to get to the same outcome. I mean, I spoke in the Chamber at oral questions today and set out the data on the increase in rape cases being reported to police, CPS charges and Crown Court receipts. So there is progress there. overall. We've seen on the latest criminal justice statistics convictions for rape up by 65% compared to the year before. I'm restless to go. I'm restless to go further. But what I would say is there's about 8 levers that we've got, policy levers, as well as the money going in. I think the Operation Satira is massive, and it touches on your point exactly. The police forces and CPS teams that now operate under Operation Satira work much more closely together. What you notice is that there's less focus or overwhelming focus on grilling the complainant, we would call the victim, but I think the person that comes forward with the reporting the crime, and more overwhelming on scrutiny of the suspect. I think that not only is the right thing to do, but means that victims are more likely to come forward. We've got all the other levers right the way through to Section 28, and we need the data, as the Chairman says. So there's more to do, but we've got the specialist courtrooms, Strasbourg, Leeds, Newcastle.
Terribly sorry to interrupt. I just want to make sure that colleagues have enough time, because we've got other things we want to talk to you about. But what you're talking about is from an incredibly low base. These are increases from fractions of the true extent of the situation. And until government ministers address the very real problem of why the police are not referring for judicial consideration the vast majority of cases, we are going to go nowhere. But presently, yes, the conviction rates are, we would always want them to be higher in the courts, but they're pretty in line with other offences. They're not out of kilter. But I think I've laboured that point, Lord Chancellor, so if you wouldn't mind, can I just go into IPP in my time? So IPP, I wonder, Lord Chancellor, whether you've read the reports of this committee. My friend Dr. Mullen was, if he doesn't mind me saying, was a dissenting voice in respect of that. But the conclusions, I think, of that report are very powerful. Have you read it, Lord Chancellor?
Yes, no, I have. Sorry, just can I? I'll come on to the IPP. I think it's a very serious issue. Just a final word on the rape stuff. I mean, on top of the fact that the volume of convictions have gone up, I mean, the way you can argue that the CPS should measure the conviction rate a different way, but the standard way, I think we've always had the statistics, is that the conviction rate is the volume of convictions as a proportion of cases brought. And actually, the conviction rate increased to 69% in the last quarter from 68%. So again, I know that there's more to do. The sort of the argument that we haven't made any progress, or the argument that there isn't important work going on, I just don't accept. On IPP, I know the committee's done a lot of work on this, and I'm reviewing the recommendations made by the committee, and I know we've got a deadline, I think the 28th of November. And I am familiar with the report. What I would just say is that we've got the IPP action plan. We don't use IPP centres anymore. It's not something that a Conservative government introduced, but I understand the history. During 2021-22, 46% of all unreleased IPP prisoners considered an oral hearing by the Parole Board were released. 24% were recommended for a move to open conditions. Less than a third had a negative outcome. So what I would just say is I think we've got a process which, of course, I would want to move more rapidly. But I think rather than relaxing or resentencing, which I think would create very real risk issues, and I think would attract real questions of public confidence, I think the better answer is to try and get those IPP offenders through the process with the support to actually pass it and move to open conditions and then to release. And we are making some progress in that regard.
Well, I would challenge that, Lord Chancellor, and I think the figures are very stark. So, as you said, IPP sentences were abolished in 2012, and there are still 2,926 people imprisoned, including 1,434 that were recalled to custody, having been released. Now, in terms of those, I'm assuming those figures are that you are aware of those. So, if we just take one of those things, that people are in prison because they have been recalled, not because they have committed further offences, or there is any evidence that they pose a threat of harm to the public.
First of all, I mean, I've given you the data about the progress we are making getting through, if you like, the stock of offenders that were sentenced under IPP. We had a review of the probation recall culture. It was published in 2020. I'm sure the committee is familiar with it. In the 12 months to the end of 2021, 34% of IPP recalls were as a result of facing further charges for new offences. But I fear that I'd be in trouble with other members of this committee, in particular Dr. Mullen, if I just said, well, we're going to re-sentence them all or let them all out. And the problem is I'm responsible for what I do. And it's the same with the approach we take to parole. It's the same. And I've got to try and do this in a coherent way and a fair way for sure, but based on the legacy that I've been left. And I don't think it's quite right just to provide some equivalent to an amnesty. I don't think that's right.
I don't think that's the case. That's certainly not what the committee is suggesting. But if we just go further, 608 have been in jail for over a decade beyond their original tariff. Something I think is outrageous, absolutely outrageous. The system would not, the sentencing programme would not have been abolished, it would not have been got rid of unless people saw the intrinsic unfairness within it. And this figure, Lord Chancellor, is, I find absolutely startling, that 188 people in prisons in England and Wales today are still in a certain thing over 10 years in prison, having originally received a term of imprisonment for 2 years or less. I find that outrageous, Lord Chancellor.
I wouldn't have voted for it first time around, but I'm left with the legacy of I deal with the world as it is. Not I can't go back. But what I'm saying to you is, I'm very supportive of taking every step I can to increase the number of people that can go through that process, which is ultimately done by the Parole Board, and to equip them to pass that test. I think that's the right thing to do.
But then, Lord Chancellor, one of the things, and you know this, because and I don't doubt your sincerity in terms of the view you're taking, but I think it's important that we air these views, that one of the quite clear, I think you've had an open letter which the committee has received regarding the support for this committee's recommendations from numerous professionals who are involved in the cycle. And I think the overwhelming evidence of this is that we have people in the prison service, in the prison system at this moment in time who are suffering from severe mental health problems as a result of the sentence that has been imposed upon them. And we are essentially keeping people in prison because they have a mental health problem rather than their actual risk to the community.
On that, I am very sympathetic. I mean, if you look at the prison population, particularly the male, although it's to some degree true, we have too many foreign national offenders, we have too many people who are effectively mentally unwell and therefore commit crimes and trip into prison. We have, with the mental health bill, and I know he's familiar with it, we're taking quite a significant series of steps as that comes through parliamentary scrutiny to end prison as a place of safety. I've worked very hard with successive health secretaries on that. We've also got a deadline, I think it's a 28-day deadline, as I recall, for moving people out of prison and into NHS care. I think that's really important. I certainly think, as well as FNOs, there are too many people who are basically inherently mentally unwell, who, because of the changes that were made, I mean, successive governments over decades have tripped up into prison, and I think it's a big issue. But I've got to do this in a responsible way. It's no good me just saying, do you know what, I'll let them all out.
We're not suggesting that.
No, I know, but that's why I'm working with the Health Secretary, and that's why we have the mental health bill, and that's why we are actually doing something on this issue now.
Lord Chancellor, on the basis of that logic, we could have a person in prison for 40 years, having originally got a tariff of 2 years.
That's what Parliament willed. We've obviously repealed the sentences, but you don't repeal them retrospectively. I'm stuck with the legacy of something I didn't vote for, but that is the way our system works.
You say we're stuck with an injustice because it was done in the past?
Look, how would I characterise it? I think we want to make sure we've got the most dangerous people in prison. I think there is a lot of soft science around risk. One of the reasons I'm pursuing the parole reform is because I am not confident we've got that balance right. But of course, there are also people that we want to avoid coming into prison. And I do think it is wrong to continue without taking steps to stop the mentally unwell tripping up into prison. I mean, I think the other one is drugs. Too many people coming into prison particularly, I think it's something like 1 in 4 in prison have previously had a heroin or an opiate addiction. I mean, if I've got that wrong, then but it is astonishingly high. Yeah. But we've typically just left them on methadone. That's successive governments have done that. I know we're diverting from IPP, but what I'm saying to you is, if we can get those offenders off drugs sustainably through abstinence-based recovery programs, and we're expanding drug recovery wings, we're going to clear out a proportion of prolific reoffenders, and that will allow us to focus on the most dangerous offenders. And I don't disagree that IPP is one of the elements of that. But I think the right thing to do is to get them going through the process in the right way so that they can satisfy the criteria that I've got to satisfy around risk.
The criteria in respect of that, Lord Chancellor, is not being applied correctly. We're having people going back into custody who do not pose a harm to the public. We have people who have got indefinite... I mean, we should all be in a position where, yes, somebody may have committed an offence in the past, but the future that these people are looking forward to is prison for the rest of their days. They've been in there for over a decade. They've got unresolved support, unresolved mental health problems. We, as a committee, received evidence in camera, from probation officers and from people involved in this process who accepted that when dealing with prisoners such as this, when they are released, there is an overabundance of caution. So conditions are put on the release of an IPP, which it's nearly impossible for them to abide by. And although some of them have committed offences, the vast majority haven't, and they've been brought back into custody, potentially for the rest of their life, on the basis of posing no risk of harm at all to any member of the public. So my final question, Lord Chancellor, is I understand from a public policy perspective what you're saying, but you, as a Lord Chancellor, as the elected politician, as the Lord Chancellor of England and Wales, you have no evidence, I would suggest, none, unless it's provided to you by somebody, about whether any of these 2,926 people pose a risk of harm to the public.
Well, I'm not sure that's... I'm not sure I'd accept that. I mean, I gave you the figure of... on recalls, 34% resulted in further charges for new offences, rather than tripping up over onerous licence conditions. I'm happy to look...
But it means 70 didn't commit an offence, 70% didn't commit an offence.
Well, I understand that, but they would have been picked up on other things. But what I'm saying is that is actually quite high. I think a figure of 34%. But I'm happy to look at the question of licence conditions again. I have looked at this before. I've scrubbed it. I've kicked the tyres, and I do want to get it resolved. But what I am left with a system whereby I will be responsible and held responsible for mistakes that are made in relation to public protection and risk. And so I've got to do this, I believe, in the right way. But I'm happy, James, to keep talking with you about it. You've articulated the challenge with it in a perfectly, I think, fair way.
I think actually, in terms of moving to the next topics, and that leads us actually to the parole board reforms, which I know Dr. Mullen is going to ask some questions about as well.
Yeah, if you forgive me, Chair, I just wanted to ask some other questions. Firstly, about the reforms we've made to sentencing for child murder.
Yes.
We'll do with sentencing parole, in this section. Yeah,
okay, well, I think I'm shooting the Bill of Rights first.
I thought it might follow more naturally now, since we've been talking about parole.
Okay, that's that and then that's parole. Okay. So just quickly, do you think that the government's description of introducing whole life tariff for child murder, as described at the time in publicity, through ministers talking at the dispatch box, in the government's manifesto, reconciles effectively with what we've done in terms of having a caveat that it has to be as a result of significant premeditation? Do you think the public think when we said we were going to introduce whole life tariffs for child murder, we meant only when there was significant premeditation?
Short answer is I don't know.
You had to make a guess.
Well, I suspect, Kieran, as you and I discussed before, if you asked in relation particularly to child murder or serious injury, the public will always, emotionally and understandably, I say this as a parent with 2 young boys, want us to take...
Indeed, and I recognise that, but in terms of my question, do you think that the public think we've done what we've done, or do you think they might think we've done something?
They welcome the increase in the sentences and Hudgell's law, and I'll always look at what more we can do to protect the most vulnerable in our society. Whether it's enough for the public...
Well, no, I'm not talking about whether they'll be satisfied, which is a different question. I'm asking about when we told them we'd introduced whole life orders for child murder, do you think that they would have expected us to only have done that for cases with significant premeditation?
It's a good challenge. The short answer is I don't know. What we try to do is make sure we target the biggest threats to the most vulnerable in our society. I drove that sentencing forward. I drove Tony's law forward, and you know, I believe both head and heart those are the right things to do, and I'll always look at our sentencing. Equally, we've got this wider debate that we discussed about who should be in prison and making sure. And so, if I may say, and I know this because I've been on the backbenches for many periods. I've done select committees. There'll always be one area or other where we want to increase sentencing. I could fill the prisons 50% higher than they are today with the kind. But the reality is we can't keep exponentially increasing the prison population.
No, absolutely not, and that's what I mean.
But you see, I've got you raising this with me. I'll have someone else on another particular aspect, and I'm sympathetic to them all.
Yeah,
but at the end of the day,
indeed,
we've got a very
yes.
significant capacity issue in our prison.
But we haven't made a public commitment to those other areas. That, you know,
Sometimes
of course, there's a wider discussion to be had. We've made a very specific public commitment to what do you think the public reaction will be the next time there's a child murder and there isn't significant premeditation and that person doesn't get a whole life time. Do you think that will undermine confidence in sentencing or contribute to it?
I think people will, I hope, understand that we've ratcheted up the sentences in the worst cases. But look, I'm sure whenever there's a child involved, it has strikes an incredible chord. I met with Denise Fergus, the mother of Jamie Bulger. I remember that case growing up. I remember that CCTV footage. I'll always be on the side of people like her, always. And that's why we're delivering the parole reforms and the various other things that we're doing. I spend my time fretting about risk, but I've also got to recognise and reconcile the resources and the capacity that we've got.
Well, on that, as a final question, the impact assessment that related to that change actually doesn't distinguish between the two, and it would seem to me actually the impact assessment and the resource assessment took into account there would be a more general application. And perhaps you could write to us and confirm what the department actually thought it was committing to in terms of numbers, and because the impact assessment doesn't make any distinction between the different types of child murder.
I know my officials are earnestly taking notes of any follow-up points. We always have a number from these sessions, which is healthy.
Understood.
The parole board then. So I understand in September you said that you thought the parole board was totally adrift from its moorings. What made you think that?
First of all, I want to pay tribute to the people that work in this area. It's very, very difficult. There's a lot of people doing an incredible amount of work, both in the parole board and in prisons and in probation. I think if you look at when the public protection test was brought in, the idea was, for those subject to parole decisions, it was very clear. You had to satisfy that there was no further risk to public protection. I think if you look at the Weeks case, that shifted. It became a balancing act between the interests of the offender, one way or another, rehabilitation, and the risk to the public. I think if you look at the impact of the HRA, the Human Rights Act, and proportionality arguments that get put in relation to Article 5 or otherwise, I think it became a balancing act. And to your point about what the public expected, I mean, some of these provisions came in originally in the aftermath of the end of the death penalty and making sure people knew that we wouldn't let people out that ever posed a risk. I think my experience of looking at a large number of cases, and forgive me if I don't talk about individual ones, typically what you have is an assessment of the risk of the offender. Often there'll be significant concerns. You'll then have a psychiatrist's report, and again, typically they will have progressed, and it may only seem like millimetres to me reviewing it, but made some progress engaging with an inherently difficult individual. I don't even cast a moral judgment, but you look at the index offence and that person is very dangerous. And then there's the passage of time. And then you look at, well, what can you realistically do with licence conditions? And we've just seen with IPP that there's a balance there. If you're going to release someone, you don't want to set them up to fail to come back in. On the other hand, is it something that can mitigate risk? Then you've got issues of straightforwardness. deceit. And I feel that as a result of all of these things, the focus on the sole issue of risk to the public has been eclipsed. I think it's true on the statutory criteria. If you look at weeks, in fairness, I think it was the Court of Appeal, someone will correct me, but the courts basically said the public protection test as specified and legislated was not specific, and therefore we need to fill some of those gaps. That's how it happened. Now the case was ebbed and flowed a little bit, but they're also proportional. And in King, I think it came back a little bit. But there are still proportionality arguments that effectively achieve the same result. So I think that the test is just not applied as a pure public protection test. There is, secondly, the composition of those parole panels. They're all good people, but I think that the approach of a social scientist, a psychiatrist, is going to be different from the approach of a grizzled detective or possibly probation officer or prison officer who is thinking about risk in very real granular terms. Why? Because they may well have gone and talked to the victim and had the horrendous duty to tell them of an appalling crime, and that will just, I think experience will suggest they'll look at it in a different way. And the composition of the parole board panels, I think it was 1 in 5 at one point had law enforcement experience. So you just have this heavy emphasis on social science in an area, and this is my central point, where it is very, very difficult to assess risk reliably. So what I've said is I want to push is a precautionary principle. I want to make sure we get back to that ability to assess risk in these very difficult cases, and in particular, where the index offence was terrorism, murder, rape, or unlawfully killing a child. And I do think that there is a case for greater ministerial involvement, and every time I look at a case and I think of my duty to the victims and to the general public, I've never gone, I mean, and this is not to denigrate what the Parole Board does, every time I've rekindled that sense of this system is not quite right. And I believe it's my job to protect the public and protect victims, and that's what I'm going to do.
Okay, and what changes resulting from the Root and Brandt review do you think will require primary legislation?
I think the amplifying the prescriptions on what risk to the public involves and the public protection test. I think the changes to the composition, and I think the right of a ministerial check in whatever form that should take in relation to that top 4 cohort. You would probably urge me to go beyond that top 4 cohort, but I'm sort of caught between the snare of James and Kieran on this, and
that's a fair representation. Perhaps
overlap
in some areas.
But I'm sure you do. But my point is that we've got to do this in a focused way, and my focus is looking at the 4 crime. What I did with this is look at the 4 index offences where the risk of reoffending and the severity of what happens is the highest.
Okay. And what's your proposed legislative vehicle for doing that? Is it a new bill? Is it some other route?
We're still working that through. Obviously, we've got quite a tight time frame, but I would like to legislate on that as soon as possible.
Okay.
Okay, thanks for that. But before we move off on parole, I mean, the test in Watson in the Court of Appeal was quite clear, wasn't it? When Lord Bingham, Sir Thomas, his name was Master of the Rolls, said, in the final balance, the board is bound to give preponderance weight to the need to protect innocent members of the public. And I think Lord Justice Rose concurred with that and said that protection, the need to protect the public is paramount. So doesn't the law do that already?
Well, preponderance,
if properly applied.
There is inevitably a balancing act. I mean, when you read the decisions, this is what they're doing. Assessment of risk. If pure assessment of risk was the exclusive or the predominant, you might well leave it there. But I think it's right that you look at the scope for managing risk, and you look at whether licence conditions could do so. But the reality is there's a balancing act that goes on in a way which I do think was not the intention of Parliament originally. And we had the balancing act in weeks, and although you're right what you say, effectively the impact of proportionality has also meant in effect we have a balancing act. And I'm just not satisfied when I've looked at cases. And look, I think I'm the only person to have successfully JR'd the Parole Board. I don't do that because I don't respect their professional view. I just take a precautionary approach to risk. I think that's what the public expect.
Okay.
Just one question.
Yeah, okay, come on.
What the word risk in this context? What does it mean to you?
Significant threat to life or limb.
So anything underneath that test, they should, from the perspective of the statutory test, a person should be released.
I don't think it's quite that simple, but if you wanted it in a nutshell, what I'm worried about is dangerous criminals who have been convicted of a serious index offence, the type I've described, going out, and because essentially it's not a moral judgment, but you're not really going to reform certain people who are either deeply mentally unwell or have a psychotic condition, and I worry that over the passage of time, with this balancing act, with the small elements of engagement that can sometimes demonstrate some progress but not nearly enough to satisfy me on risk, I worry a little bit that we've got the balance wrong.
All right. Now, understanding your objective as to you think give greater assurance to the public and therefore do ministerial control. How do you square that, though, with the common law position as well as the European Convention position that the Parole Board is and should be regarded as a court for these purposes, therefore an independent court? So isn't there a danger that you trespass upon that status?
There is, which is why we've got a review mechanism to the upper tribunal. But what I would just say is, I think it's an interesting question of, we talked about this. Is it a public protection test, or is there a balancing act going on? I think that the Parole Board's function actually is mischaracterised as judicial. Whatever the legal label, I think its sole function should be assessment of risk. By the way, I think that is a very difficult assessment to do in these kinds of cases, given the passage of time and given the conditions. So actually, I think it should be more of a fact-finding, inquisitorial process. And the fact that it's regarded as a judicial process in the way that I think, Bob, you and I and the committee understand it, tells you that there's this balancing act going on. Now, of course, I think there should be strict parameters and strict criteria on it. I can see all of the risks involved. But fundamentally, I think what people expected with a public protection test was something pretty binary. I'm not sure that's what they're getting.
Okay. But in achieving that, do you accept that there's a legal obligation to ensure that decisions which concern the detention of an individual have to be taken by an independent court?
Yes, but these are people that have been convicted of a criminal offence, and on top of that, in relation to, and we're only talking about those 4 most serious categories of cases. I mean, I think that quite a lot of the work that I would like to see to rebalance can be taken care of by the criteria and the composition of the but in relation to the top cohort of the 4 particular offences, I think it's right we do this, and I'm happy and indeed our proposals will include, as I set out in the root and branch review and the response we did to it, the proposals we set out in the House of Commons, to look at something akin to a judicial review check. What I don't want to do is have a court substituting their judgment and opening it up to a merits-based review with the balancing act or proportionality. We're just back then in the same old place. And I think there's scope for addressing this with Strasbourg.
Okay. The Victims' Bill, for example, had pre-legislative scrutiny. Would these legislative proposals to reform the Parole Board be appropriate for pre-legislative?
We did the root and branch review, and that was consulted on, and I've set out the government's response to it. So it's not something, I mean, there's not it won't require as many clauses as the Victims' Bill, so I'm not quite sure it needs full pre-legislative scrutiny, but I'm really happy, as I hope I've shown, to come back and talk to you about it again.
Thank you very much. Mr. Maynard, you would come on a specific point.
Thank you very much. Patience is its own reward, so they get to me eventually. We've been doing a greatest hits tour of the committee's work. We've done IPP. Let's now move on to the Victims' Bill. We did a report on. Our clear view was that the powers given in the Victims' Bill didn't really strengthen the role of the Victims' Commission in the way that we expected it to. Is that a view you might share?
Look, I looked at this very close. You're talking about the generic role rather than the current.
Yes.
Look. I mean, first of all, can I just say, on the subject of greatest hits, I read at length your report. I think you had 47 recommendations. We're going to be publishing our response to that very shortly now. And I genuinely was impressed with the report. I'm not just saying that. And we've taken on board a number of the recommendations. I think I just want to be careful with the role of the Victims Commissioner. I found an incredibly important role. I think there's more that can be done, but I don't want to create a distortion of functions that are already challenged. And so it's trying to make it work in a complementary way rather than in a way which would have that effect. But look, I understand the argument made. The truth is, I think, we set out what I think the priorities should be. I think there's a big issue around expectations. I do think it's reasonable to expect that a CPS lawyer in the most serious types of cases, I'm not talking about a straitjacket requirement, has, before the case goes to court, gone and met with and at least had some conversation with the victim. You can see in rape cases why the trust issue is so important. I think on accountability, I think there's a significant piece of work, not least given the points being made about the operational independence of each of the agencies, to have something bring a more concerted cross-cutting approach, both at national level for the inspectorates, but also PCCs. So I think there's a significant piece of work to be done. There is a balance in the criminal justice system. What I want to be careful is that we help fine-tune it and we don't upset it.
You mentioned your caution over the enhancing the role of the Victims Commissioner, and you're clearly being very cautious indeed with the role of the Victims Commissioner to the point that you suspended the competition process for the new appointment. Why did you suspend that particular competition?
Well, first of all, I suspended it because basically it's so important and I wanted to get a wider field in, and that's just a judgment call that I made, and that's not to denigrate the previous applicants. There was a very high standard, but I think it is so important. But I can tell you we're making, I think, smart progress on this. The recruitment campaign is obviously already underway, and we expect to appoint Commissioner as soon as possible in the new year.
Given that the previous occupant, Raab, was told by officials that she was appointable, is there an explanation for why you then subsequently chose not to appoint her despite her appointability, and the fact that you did not choose to meet her during your previous incarnation in this role?
Well, that's not true. I did meet with her. So that is simply not true. And indeed, I've got great respect for Raab, and I think she did a really good job. I think the role has evolved, and I also think, I also extended her period in the role. So there's no criticism that I have of Vera, but I also wanted, it's my job to do the very best thing I can, and I also thought there was a case for bringing in, opening up to open competition. And I take that very seriously. I'm a meritocrat at heart, but most importantly, I believe we can find an exceptional fit for the role in the current climate and with all the challenges we face. And ultimately, I think that's my duty.
I don't doubt what you say, but just for the record, I quote a resignation letter to your predecessor. It was notable that the previous Secretary of State had not met me once since February, so she is saying that a significant reason why she resigned was not being able to meet you.
Wait, sorry, we've gone from saying I hadn't met her at all to I hadn't met her between February and I'm pretty sure, but I can come back to you with when I did meet her, and of course, but I'm pretty sure I met her virtually as well as met her in person.
That might well be the difference between the two elements. You say in the new year you're hoping to fill the role. Was that correct?
In the new year.
Yeah.
Or by the new year?
In the new year.
So it could be at some point in 2023.
Yes, look, but the process is already underway. I get that there's a gap. I want to fix it as soon as possible. If you ask me whether I want to do it quickly or get the very best pool and appoint the very best candidate, it's the latter.
Okay. And then finally, once again, as part of her letter to Brandon, then Vera said that the Bill of Rights bill undermined what little progress the Victims Bill was set to bring. How would you respond to that particular criticism that your focus on the Bill of Rights bill risks undermining that Victims Bill?
It doesn't.
Okay.
If someone can point to me to a clause in my Bill of Rights that undermines a clause in the Victims Bill which has gone through pre-legislative scrutiny, I'm happy to answer it. I do not believe it does. I think we need both of those things. This is a a compassionate government who also sees that doing the right thing by victims is going to drive progress in outcomes in the criminal justice system. And of course, the Bill of Rights is there to make sure that the process can protect victims and can protect the public, perhaps more than was been possible under the HRA.
I asked Mehdi to help segue into your Bill of Rights questions.
But the Victims
Bill,
elegantly done.
Very, very nicely done. The Victims Bill and the Bill of Rights are your two legislative priorities. In terms of parliamentary time, which one's going to come first?
I would expect the Bill of Rights to come first.
You think it's more important than the Victims Bill?
I think it's not so much that. It's just where it is in the. I mean, the bit that we haven't yet responded.
They haven't responded to the consultation.
Yeah, and the Bill of Rights is ready to go. It's already been published. But there's two things aren't. I mean, I don't really accept the conflict. The bigger challenge we've got is the funnel of important stuff that the government with the reforming agenda is pushing through. But we'll do both.
I'm just thinking 2 years left in this Parliament, a bit more, just making sure that...
Yeah.
Have you agreed time with the business managers yet for the Bill of Rights or the Victims Bill?
Very close. Bill of Rights is coming for second reading shortly. I want to get to the same position as soon as possible on victims and whatever else goes with victims.
Okay. Dr. Martin.
On the Bill of Rights, are there any areas of the bill as originally published that you intend to amend before it comes back?
Not before it comes back.
So it will come back in exactly the same...
It's not. I don't think it's gone away. It hasn't been... It's there.
What about in the course of its passage through the House?
Well, as you... So, Robert, you know that I will always engage constructively, and I suspect there'll be some interesting conversations in the House of Lords.
I guess that dynamic is about whether you're kind of persuaded by others to make any changes. From your perspective, given the time that's elapsed and the discussion, are there any things that you're personally minded to potentially change or not?
I think we've got a great bill here, dutifully tabbed. I did it myself before Carl asks. There's one area where I'm looking for a legislative vehicle, which is SLAPS. But as I say, but I think it was something like this. This is a significant constitutional step forward. I think, as you know, I think there's a really strong case for strengthening free speech, for preventing the abuse of the system around foreign national offenders. There's other things that I think we need to do. I think parole reform will need to have the latitude the Bill of Rights will provide. Yes. I think if you look at some of the very topical issues that we've got inside our high security estate, we're already getting claims under the HRA. I mean, the people that say the HRA, the goalposts don't shift, we're already getting claims from convicted terrorists or Islamic ideologues claiming a right to socialise within the prison population when we want to use these separation centres to prevent that risk, both to the wider prisoner community, but also ultimately the public. These are all the reasons we want to do it. And there'll be a chance, it'll be, I'm assuming, but again it's for the business managers, I'm assuming committee stage will be on the floor of the House.
Yes.
And of course I want to listen very carefully to what colleagues have got to say. But we spent a long time looking at this. This was our manifesto in 2010, you'll remember that. I looked and did a first draft for consultation in 2015. And we done a consultation again on the not just the policy proposals, but a bunch of text. We've been thinking about this for a long time. I think it's time to do it. But you know, I'm always willing to listen.
Okay, you'll be aware that the concerns that anything that we do in relation to the Human Rights Act might interfere with the Good Friday Agreement. So I'm just wondering if you've had any engagement with the Irish government on that issue.
So first of all, in terms of the Good Friday Agreement, and I've been out to all the devolved administrations, so I've spoken to politicians in Northern Ireland, I've spoken to the Judiciary there, we've done round tables, David Wolfson, Lord Wolfson and Lord Bellamy now have done round tables in all of the administrations. The position on the Good Friday Agreement, I think, is very clear. We're staying a party of the ECHR. On top, and I think that satisfies the issue with the Good Friday Agreement. On top of that, as was the case in the Human Rights Act, we are incorporating into the schedule of the Bill of Rights the European Convention. Now, the big changes are therefore about the procedural framework, how the rights are interpreted, and whilst that does have some substantive impact, it's nothing that would affect the function of the Good Friday Agreement. And I can say that confidently.
And are you kind of concerned by people like Lord Dyson, Lord Mance, senior retired judges criticising the Bill of Rights?
Look, I always listen. I could give you a string of names of former judges who have written and current judges, and judges when they were current judges who have extrajudicially written about the problems with A, the Human Rights Act, and B, the Strasbourg case law. Lord Sumption seems to be writing frequently about this. So I always listen, but fundamentally the things that we're doing I think are right to restore some common sense, to articulate a more UK-wide set of priorities for human rights, and to curb some of the abuses of it. And I mean, feel free to put any particular. I mean, I've got the thing tabbed for a reason. Put which is the clauses of the Bill of Rights that are subject to these criticisms. I think it is right that with sections 2 and 3 we reduce the pressure to follow Strasbourg case law. We should be articulating an autonomous UK set of case law. I think it is right that we stop the process of allowing courts to amend legislation. It is for Parliament and elected lawmakers to do that. I think it's right that public protection should be ascribed greater weight, particularly when it's set out in primary legislation. And I think there are good policy reasons and areas where we'll benefit from doing that. And there's a constitutional point here about the separation of powers. I believe in a robust judiciary. It was Labour that created a Supreme Court. Some people on our benches didn't think that was a good idea. I personally am very comfortable with it. I would like it to be supreme, not subordinate.
Okay.
All of these things are spelled out in the Bill of Rights.
Right. Do you accept on that narrative that it's more likely that we'll lose some cases when they go towards the European Court?
We've got an exceptional record, and I would imagine and anticipate that would continue. But just to be clear on this, I think there's a misunderstanding, and we often do this as common lawyers who apply a doctrine of precedent. Often on the continent they don't, and they don't have a strict doctrine of precedent in Strasbourg. And that is partly, if you look at the change and the shift in the Strasbourg court, they talk about an age of subsidiarity. Now, Robert Spano, the president, has just transitioned. He's not there anymore. But I think the European Court has been on a journey. They had the age of the living instrument. They now have the age of the subsidiarity. And they have always recognised the ability for us to engage in dialogue with Strasbourg on these issues. So it is absolutely legitimate, lawful for us to test the margin of appreciation, to avail ourselves fully of it in those areas where there are vital interests at stake. That is not some kind of grubby, unlawful thing to do. We shouldn't be gold-plating things because of Strasbourg any more than anywhere else.
Okay.
We should be, and part of that, and Strasbourg has said this, is about having a dialogue with Strasbourg, and the Bill of Rights sets out a process for doing that.
Okay. I mean, I guess one of the things that I've noticed, whilst been having some sympathy for your argument, is actually when you look at the case law that was in the original documents that accompanied the bill, from many, many years ago, the cases that we're kind of flagging as examples that we might lose. I appreciate the Rwanda agreement is going to go before the courts, but outside of that, are there actual specific cases that, where we wanted to do something and we haven't been able to do it because of the case law?
Yeah, absolutely. And the case law from the Human Rights Act. The obvious one is deportation of foreign national offenders. I mean, personally, and other people may take a different view, I don't think we should ever send someone back to the arms of a torturing state. I think the prohibition on torture is absolute. And people talk about pulling out the ECHR. Even if we pulled out the ECHR, that is written into various other international conventions and indeed primary legislation and indeed the common law. But I think the use of, for example, Article 8 and the right to family life by foreign national offenders to frustrate deportation orders. And if you look...
There are recent examples of that.
Let me just... I'll be brief. Okay, I know you want to get on. But first of all, the Strasbourg court, at the time that the UK courts under the HRA were using Article 8 as a fetter for deportation, it came first in the UK courts. Then the Strasbourg court, presumably followed that. So it's a good example of dialogue, actually, although probably in the wrong direction, and a good example of if we gold plate the approach that Strasbourg takes, we're going to end up unable to deport serious foreign national offenders. And I think when I looked last and I published this data in the consultation, some 70% of successful human rights appeals against deportation by FNOs are still Article 8. Bear in mind, in recent history, I think it was in the early noughties, so some point between 2000 and 2010, was the first time in its history the Strasbourg court had ever relied on Article 8 to trump a deportation order of an FNO. Now, 70% of the successful appeals in the UK based on that. That was not something that we actually necessarily should blame, at least initially, on Strasbourg. It started here with the elastic interpretations of human rights and the shifting goalposts. I don't think that's right. By the way, I don't think it's right because I want to deport more foreign national offenders. I don't think it's constitutionally right.
I mean, one of the things I've picked up from talking to ministers is that actually some of this doesn't get to... You can't necessarily evidence the interference it has on decisions we might reasonably take, because ministers get advised you can't do that because it wouldn't survive. Whilst actually, so is that perhaps a challenge that we're going to struggle to evidence stuff because we've started to behave differently in anticipation of what the courts might do?
It's that, Kieran. But the truth is, there's loads of cases on Article 8, and you can track when they first started coming in, and you'll see that they started coming in under the HRA, and then Strasbourg followed suit. Secondly, you've got the cases that, because of the precedents, are lost, and that's why I think that figure of 70% is so important. Thirdly, you then have this chilling effect it has, because people bring legal cases and we think, well, if we can't, it's not a responsible thing for me as Justice Secretary and for any government department to take on cases where we don't have a good, reasonable prospects of winning, and that then starts to have a chilling effect. And a good example of this now is these separation centres in high security prisons. We're starting to see these, and what I worry about is with those shifting goalposts, we lose the ability to protect the public in what is a clear, vital area of security. By the way, in terms of evidence, that this has happened. I mean, the argument isn't that this has happened. The Strasbourg Court has been saying for decades the ECHR is a living instrument and they can expand interpretations of it. What that basically means is they can expand and change what is written into the European Convention. There's a basic problem with that. In fairness, and it's clear that to some degree has been echoed, mirrored, indeed expanded in the UK under the Human Rights Act. We've got judges talking about this. The idea it's not documented is not serious. I think the more credible argument is actually both the current Supreme Court and the Strasbourg Court under Robert Spano has, as things flowed, things have ebbed back a bit. I know, Bob, you've made that argument. I think there's something in that. But what ebbs may flow, and we are absolutely entitled to codify the right of...
Why be party to it? Well, aren't our judges more than capable of making all the decisions all on their own without having to refer to a higher court?
Well, there's two different arguments. There's one, just repeal the Human Rights Act. I don't think, and I looked at this argument, I've heard serious people suggest it. I think if you take from that period of over 20 years, the case law that has accumulated, if you just repealed it and didn't put something else in its place, I think the judges would fill the gap, and therefore you'd have at least uncertainty, if not similar sets of problems. In terms of pulling out the ECHR, look, I've heard people make the case for it. I'm not sure pulling out the ECHR will solve the problems people think that it would. I don't think you would solve all the small boats problem. The Bill of Rights will help in some material respects, but it won't solve the whole problem, and the Home Secretary's quite rightly said there's no silver bullet. Pulling out the ECHR won't. The principle of non-refoulement, you can't send someone back where there's a well-founded fear of threat to life or limb, and that goes far further than the ECHR. And the ECHR, as you, I think, Kieran mentioned, is written into the Belfast Agreement. So I can see the immediate downsides. I'm not entirely clear what the upsides would be. I think there would be more marginal than the advocates would suggest. The government's position is we wouldn't rule it out. I just would, like anything, I want to have a proper cost-benefit analysis of it.
Okay.
Okay. Right. The manifesto that you and I were elected on, Lord Chancellor, in 2019 was to update the Human Rights Act. It wasn't to repeal it. You've gone well beyond the manifesto, haven't you?
I don't think so, Bob. I've heard this argument as well. Look, I think people are accusing us of two different things. I hear it all the time. We're going to rip up human rights. There's a threat to this, that and the other. All the cases that were won under the Human Rights Act notionally. I mean, and on the other hand, there's other people. I've got a list of all the quotes of the critics here that say that actually it won't make much difference. They can't both be right. And what I would put to you is that actually this is an incremental reform. We're staying within the Convention. The Convention is incorporating the schedule. The big change is the procedural framework for interpretation. It will make some substantive differences in the ways that I've set out. But equally, I mean, I think that's a very British, and if I dare, may say a very conservative approach to reform. I think it's material. I think it is if you look at the approach to human rights over the years, I think it is evolutionary rather than revolutionary, but I think it will make a real difference. And I've set out the areas from free speech to FNO deportations to separation centres where it will help us protect the public.
I mean, your predecessor, when he set up the independent review on human rights, initial predecessor, I can put it that way, Sir Robert Buckland, asked Sir Peter Gross, very distinguished former Lord Justice of Appeal, to carry out a review. He did that in over a better part of a year. Some very detailed evidence to support his recommendations, which, frankly, you've sidelined. Why is your evidence base better than Sir Peter's? Why not build on what he did?
I think we have built on what Sir Peter did. I mean, he had some interesting analysis on sections 2 and 3.
Yeah.
He had some interesting analysis on extraterritorial jurisdiction. I mean, I looked at it very carefully. I think I'm very grateful for what not just Sir Peter but the whole panel did.
Yeah. Yes,
and so that's a good example of where we did look at the evidence. I think you've ultimately got to decide how extensive you want the reform to be. And what I wanted to do is what I consider a common sense approach, is to look at strengthening the rights that I believe we should strengthen free speech because of, I'm reluctant to call it the wokery, but the combination of things like judge-made privacy law to the stifling of free speech, whether it's on academic campuses or elsewhere, or indeed on Twitter, or wherever it may be, right the way through to the other areas where actually we need to qualify and caveat the rights, as most of the non-absolute rights in the Convention permit explicitly. They allow for qualification in a way that protects the public and stops this constant shifting of the goalposts. I think we took a middle course in all of this, if I'm honest. I think it was the sort of madras on the curry menu, not the korma, but not the vindaloo. And in fairness, I looked at all the evidence. I looked at what Sir Peter said and did. I've looked at others who have said we've got to pull out the ECHR. And again, as I said in answer to the earlier question, I looked at the cost-benefit analysis of that. So I'm all up for looking at evidence. I think this idea, though, that the HRA has not impacted on public protection, I'm afraid if you do a thorough analysis, it's impossible to square with the facts.
Well, would that thorough analysis be published when you bring the bill back?
We set some of this stuff out in the consultation. We set it out when we published the bill. I've talked about the areas, Osman rulings. We've highlighted some of the police forces where, as a result of that straitjacket, if you like, regulatory burden imposed by a court, not by the Chief Constable or a PCC's view, or let alone elected Parliament, it has perverse consequences. And that's not to say, ultimately with Osman, it's a good example of where, of course, there needs to be accountability, but I think it is right also when it comes to the allocation of public finances, when it comes to operational judges on the front line, the accountability ought to be via the Chief Constable, the PCC, Parliament itself, elected ministers. I don't think it's right that we have effectively straitjacket regulation coming in through the back door via court. I just don't think that is right. And I do think that has had an impact on the resource and the discretion that I think most people would expect their police forces to be able to exercise.
The impact assessment does say it's a likely consequence that we will lose more cases in the ECHR, and it would be harder for people to enforce their rights directly. Is that a price worth paying?
I don't believe that's what will happen. I think
that's what the impact assessment says. You publish it.
No, look, we look, and that shows you how dispassionate we were about it. I think we are entitled. So first of all, in terms of cases, the recourse to the courts will be there in the usual way. I think it is right to say that courts should make a declaration of incompatibility, challenge public bodies that exercise unlawfully. It is not right for them to change the law or expand human rights without elected MPs having accountability. In terms of going to Strasbourg, look, we've got one of the highest compliance rates.
Yes, absolutely.
But I do think every now and then it is right for us to test and challenge parameters, particularly when they're fluid or where the case law has been going in different directions. The obvious example I give is prisoner voting. We had all of these arguments around prisoner voting. And I remember, because I was Human Rights Minister in 2015 at the time, we didn't give prisoners the vote. Parliament considered it. It's the right thing to do. Then we engaged in dialogue with Strasbourg. I went out to the Committee of Ministers. We put the argument to them. And after a fair amount of toing and froing, they accepted it. That is a legitimate thing to do. That is something that was within the framework of the Council of Europe. So being able to go to Strasbourg on occasion, I'm not talking about on a weekly basis, but to test the parameters where we think the balance is wrong and we've got a good argument, both a good legal argument, but also a strong and overwhelming policy argument, I think is a legitimate thing for us to do.
You can do that within the current framework.
Yeah, we do, but because we gold plate so much at home via the HRA, we are much less able to do that when we think there's something vital at stake.
Mr. Turner.
Thank you very much indeed, Chair. Talking of Sir Peter Gross and his analysis of the bill and indeed his discussion on Section 3 of the Human Rights Act, I think it's fair to say that he thought only a very minor amendment to Section 3 was required. So why does the bill repeal Section 3 in its entirety? I suppose for those who are watching, Section 3 is the provision where courts are required to read domestic legislation down in order to give primacy to convention rights.
The crux is with Section 3, I don't think it actually is repeal. I mean, of course, the clauses and the provisions are maybe in a different place. It certainly overhauls it. I don't think it's quite right to say it repeals it in its entirety, but the reason is it is wrong for a court to amend legislation. It is right for that to be sent back for Parliament to reconsider.
Well, before I ask you about giving me an example of where Section 3 has been a problem, a recent case would help. Clause 3, subclause 3A states that the courts cannot expand the protection of a right unless the court has no reasonable doubt that the European Court of Human Rights would adopt that interpretation if the case were before it. Can you explain?
Which clause is it, the HRA or the bill?
It's the bill. That's the bill. I just wonder if you can explain why you chose to frame the provision in that way, because that seems repeal.
Clause 3. Like which one is it? Clause 3.
3A, I think it is on 3A. My brief. Have you got the bill?
The court cannot expend the protection of a right, quotes, unless the court has no reasonable doubt that the European Court of Human Rights would adapt that interpretation.
I understand. Yeah. What we're trying to avoid is precisely the rights inflation happening through incremental expansions of interpretations of rights, and it's important. There's a difference between the application of a legal scope of a right to the facts and expanding the legal interpretation of the right itself. If we're going to change the law, it should be done by Parliament. The courts are there to apply the law. That's the crux of it.
Well, is there a problem with Section? Can you give me a recent case where Section 3 of the Human Rights Act has been particularly problematic? Well, as far as you're concerned.
Section 3, particularly
because we're talking about the fact that you're repealing Section 3 in the bill.
So
why is there a problem, in your view, about Section 3?
Section 3 is often operated with Section 2.
Yes, of course, it's got an interrelationship, but give me a case where there's a problem.
Off the top of my head, I can't. But
Can you write to us about that?
Yeah, it's actually it's in the consultation. We spent some length looking at this, so it is already there. We published this as part of the original evidence base.
All right, Mr. Day.
Lord Chancellor, can I just take one step back, just very briefly, in respect to the Victims' Bill, because obviously we talked about Vera Baird and her views in respect of that. But I asked you a question earlier on regarding the approximate 70,000 allegations of rape this year. 2,200 approximately have gone to charge. The Victims' Bill as it is currently drafted and as how you foresee it, would the 68,000 people who have made a complaint to the police of rape, would you consider them to be victims of crime now, and certainly under the Victims' Bill, would they be viewed as victims of crime?
You mean will it apply retrospectively?
What I'm trying to say is that the Victims' Bill all depends on what one perceives a victim to be. Yep. Now, if 70,000, I could pluck any figure, any hypothetical figure, but I'm trying to use one that we've got here. Yep. If you've got 70,000 people who make an allegation of rape, and only 2,000 of those lead onto a charge, I'm assuming the Victims' Bill will mean that the 68,000 will be considered to be victims of a crime.
Let me write back to you with the definition. And and I know you've made some recommendations
Yes.
On this. Let me write back to you with what we've settled on as the precise definition.
The prisons, just one.
Yeah, yeah.
We're just going into prisons now, Lord Chancellor.
Onto what, sorry?
Into prisons.
Yeah.
And it goes again back to something that was touched on in my earlier questions and those of colleagues. And if you just give me 1 second. I just wondered why you feel greater ministerial oversight of moves to open conditions are appropriate. I think it changed in 2022, didn't it? And again, this relates to IPP prisoners in particular, and seems to be another bar in IPP prisoners being referred to open conditions, which may be people with mental health conditions and everything else.
So that was a change I made, and it was based on risk and commanding public confidence. The risk, of course, we want people in open conditions. I mean, no one is a bigger advocate of that journey than me. And one of the big successes we've had is increasing again in 1 year the volume of offenders released within 6 months, the proportion of them, going into work by 2/3. And that won't happen if we can't use open prisons and some of the Cat C estate as well. So I want that to happen. But the problem is, the risk is, if people abscond or if people move and there is a problem with it, it undermines public confidence. We've got to make sure we carry the public with us. And I think I can write to you with the cases. There are a number of cases that raised concerns about this. So the threshold for me blocking it is pretty high, but equally I want to make sure we protect the public, and I want to make sure public confidence are with us, and that is precisely because where it's appropriate I want more people going into open conditions, more people because of the reoffending and the work programmes we can get them onto.
How many decisions on average each year will be affected by the change in policy?
I'll write to you with the details, but it's not a huge amount.
And will the reduction in moves to open prisons for top-tier prisoners lead to an increase in that cohort, which is an important question, being released directly into the community from the closed estate?
It will depend, of course, on whether they're a determinate or indeterminate sentence.
Okay. One of the pressures, of course, in the closed estate is that we know that some 700 cells are lost each year because of their physical condition. What are the plans to deal with the physical fabric of many of our older prisons, which the lack of those cells, of course, putting more pressure on an already overcrowded estate?
Yeah, it's a really good point, and I've made this argument with our Treasury friends that it's a false economy, because if you lose those prison places, it's the same in the courts estate, you end up paying more to deal. So I think prevention is better than cure, and the way I look at the maintenance budget is one of the reasons you want to be very careful about avoiding it being penny pinched at times of financial pressure, is because of that. I think the only thing, and so obviously we've got the new settlement post the autumn statement, but it is one of the things that I want to protect, because I see that false economy. The other thing I think it's worth saying is the investment in the fire safety gives us the opportunity to upgrade something like 30,000 cells to modern fire safety standards by 2025, 2026. And so making sure that we do that will actually not just save us losing, but will bring in extra cells. So to be honest with you, I think it's a good deal in terms of, I talked about the pressures I've got on a limited budget. I mean, actually, I think investing in the maintenance, whether it's in the prison sector or the courts estate, is actually a sensible move, because it yields quite a quick operational dividend.
That's a priority. That's
yes.
Helpful to know. What about the issue of retention of staff? Because we do know that there's a significant turnover of Band 3 to Band 5s. For example, I think some of the evidence that we've had suggests that 19% of Band 2 operational staff leave the service within 12 months. There's clearly a problem there on recruitment retention.
Look, let me start with my view, having come into this as Justice Secretary a little over a year ago. I think the role that our prison officers do is second to none in the public sector. They're out of sight, out of mind. There's not people banging pots and pans together for them, which is, they don't get that recognition. They deal with some of the most difficult things, whether it's from the prolific offenders who are constantly reoffending through to the very high security estate. What are we doing about it? I mean, we launched this retention toolkit in prisons, which helps governors identify, particularly in their local context, the most appropriate interventions. I think that's important. I'm trying to give prison governors more autonomy where I can to cater for the local needs. We've also tried to streamline the efforts and the delays and the bureaucratic hurdles to recruiting prison officers. We want to be careful with that because there's, of course, a serious issue around vetting and fitness checks. We announced earlier this year, the Prison Service Pay Award, which was, of course, the consequence of the pay review body. It's delivered at least a 4% award to all staff with additional investment of, I think it's £3,000 increase in Band 3 prison officers. I believe that is starting to have a positive impact. And all of those things go together. I also think, as I said at the start of my answer, we need to find ways to recognise what is, I think at times, a heroic job that they do. And of course, during COVID, again, out of sight, out of mind, again, an absolute stellar job. And I think my predecessor did an incredible job as well. But I know he would immediately give credit to the prison service.
I think we'd all join in that. Is it time, perhaps finally, to develop those initiatives like the toolkit and others into an overall prison workforce strategy, particularly as we're going to grow the number of prison places, it's planned. That's going to require more officers, particularly in the band, in the band 2, 3, 5s.
Yeah, calling it a strategy, calling it a tool. I mean,
whatever. Yeah.
I mean, look, I'd be interested in your views on that. If you guys look at that and think that there's more we can do, I'd be very open-minded.
Perhaps we can return to that topic then, particularly important. Very well. Unless there's any other questions from colleagues. Well, Chancellor, we've had a lengthy session. Been very grateful to you for your time and for your evidence. I'm sure it won't be the last time that we discuss some of these topics.
Thank you. It's always a pleasure to engage even on the difficult issues. Thank you.
Thank you. Session is concluded. Order.
House, the Grimmond Room. The proceedings